This week on Lewis on the Law, I've got another great show for you. In the interest of empowering you, the listener, we're going to talk about a very important field. That's right. We're going to talk about what to look for in an attorney, what to look for while your case is going on. We're going to talk about legal malpractice.
Welcome to Lewis on the Law.
You are listening to Lewis on the Law. My name is James Lewis, and I'm your host this week and every week. And I have yet another great and empowering show for you, the listener. I am so honored to have attorney Bret Moore from Bret Moore Law on with me. And today we're going to talk about a really particular area of law, something that everyone should know about, especially if you're looking for an attorney, if you have an active case and you want to make sure it's going in the right direction. Today, we're going to talk about legal malpractice. Now, Bret, I know that you do more than just go to battle with other attorneys. Why don't you tell them a little bit about your practice?
My practice is split about 50-50 between personal injury cases and legal malpractice cases. So a lot of my practice is focused on suing lawyers for plaintiffs when lawyers have made errors and screwed up their clients' cases. I do a little bit of legal malpractice defense, not a lot anymore. I also do some bar disciplinary defense as well.
Okay. So you are the type of attorney that I absolutely do not want to hear from. I do not want to see a letter from your type of attorney. And we get a lot of attorneys out there who are listening to this show. So you're like, oh God, no.
Yeah. I mean, it's one of those things where you don't win a lot of friends because of the practice area. However, listening to the intro, like I got all pumped up, like I'm ready to run through a wall because this is an important thing, right? No one is above the law, and that includes lawyers. And a lot of times, they're going to want to deny that they did anything wrong, that sort of thing. So.
You're absolutely right. No one's above the law. And this show specifically is about empowering the listeners with legal information. And I want to throw out this disclaimer real quickly. This show is designed to give people legal information on what to look for in an attorney, what to look for in your case, what type of issues you might need to preserve. It is not meant to replace the advice of an attorney. If you have a serious legal issue, you need to go ahead and contract with an attorney, and don't take what you hear on this show as legal advice. Now, one thing good about this show is almost all the attorneys that appear on this show have been recommended to me. So you can listen to our show, go through it, and I let all the attorneys give contact information. So you can pick attorneys off of my show. And you can feel safe that these guys, if they're not perfect, they're going to do the best job they possibly can for you. Okay. Big topic here today. Big topic. Big. It is a big topic, and you're right. The intro is all about it. And I haven't said this in a while, but I actually wrote the music for that intro and produced it in my basement studio. Yes, I had a past life as a musician, which didn't pay me anything.
Right.
Maybe I needed to be a better musician. Anyways, let's get into it. Legal malpractice. Where are we starting here?
Well, sort of the threshold question that you have to answer as a person. Is there are certain things that you need to have in order to have a legal malpractice claim. First and most important is you had to have an attorney-client relationship with that lawyer. Mm-hmm. A lot of times people call me and they're like, Is
that a problem, first establishing the attorney-client relationship?
It can be. I mean, a lot of times I've had people call me and they say, oh, well, the other side's lawyer did this, and this, and I want to sue them. No.
Yeah,
you can't do that. You didn't have an attorney-client relationship with that lawyer.
I've actually had that question thrown at me, and I had no way of handling it. And I was basically, no, you can't sue their lawyer for winning their case. That's not going to work.
Right. And then assuming that you have that, then the lawyer has to have done something or failed to do something. They should have done something wrong that's messed up your case or your claim or whatever it is, or they should have done something and they didn't do it. Mm-hmm. And then that's, it's sort of a typical negligence kind of cause of action. You have a duty, you breach that duty, and then there's some component of damages. Mm-hmm. How did that harm you? A lot of times in family law matters, and these are very common for people to call complaining about their lawyer. They're mad.
Mm-hmm. Family law? What an ugly area of law. I just have to say that's one of the ugliest.
It's tough, but it's very hard to have a viable legal malpractice claim arising out of a family law matter because they can almost always be modified. And if someone can go in and fix whatever the problem is, then there's no damages, and so you don't have a viable legal malpractice claim.
Okay, so damages are important, but let's go back to the beginning of this. Okay, when you're talking about a duty for the attorney to the client, I mean, aren't you just talking about, hey, my duty is to win my case for my client? What are you talking about when you're first talking about duty? Let's go ahead and break down all these elements.
Right. So obviously a duty is you have to advocate for your client or do something that they're asking you to do. It could be, I've gone to someone and asked them to draft a contract for me. If you've received some payment, then you now have to do that work.
Okay.
If the client has paid a retainer to the lawyer is billing them by the hour, then there is some duty for them to do something on behalf of the client. A duty can arise without payment, though. A duty can arise without a written contract. You don't need a written contract.
Yeah. Now, that's one of the things I'd like to throw out a disclaimer during almost every single section of my show, because I don't want at any time for there to be anyone who comes in and heard this show and said, I got my legal advice from James Lewis, and I am, I don't want there to be any question. But get into that a little bit more. How else can a duty be formed without payment?
Yeah, I mean, pro bono, any kind of pro bono matter. If someone at your church asks you as a lawyer to do something and you do something for them, that carries with it every aspect of the attorney-client relationship that any other engagement does. So that person is just as liable to that client to do what they're supposed to do to the maximum of their skillfulness.
Even if they don't get paid, they can still be sued
Correct.
for legal malpractice?
Very, very true. Yes, correct. And I guess the standard, too, is what would an ordinary lawyer in the state of Georgia do in similar circumstances and situations?
That's very, very important. I'm glad you threw that standard out there.
Yeah, you're not entitled to the best lawyer in the universe. You're entitled to someone who is the bare minimum, basically. That's the floor. That's kind of... That's what the person has to kind of live up to, and it's a low bar, particularly in an active litigation case. There's lots of we're going to get to it, I'm sure, later on. There's lots of defenses to legal malpractice claims, and some of those can arise in when you're actively in court doing things, making decisions, on a snap basis, that kind of thing.
Yeah. Okay. So we've gone through duty a little bit, and I think that's a pretty good touch on duty. How then is an attorney breaching that duty?
Well, it's really simple. They didn't do what they were supposed to do, or they
didn't do what an ordinary attorney would do,
or they did something wrong. They just made a mistake. They were supposed to do it this way, and they did it that way.
So I think causation is usually pretty easy to tie to, or am I oversimplifying that?
How much litigation do you do?
I don't do a lot of litigation. I'm a transactional attorney, so yeah. So I mean, every now and then I send threatening letters, but they almost always settle, especially in real estate transactions. Everybody wants to settle.
Yeah, I mean, causation is actually probably the most fertile ground for defending a legal malpractice claim. It's the most difficult thing to establish. This is where you have to show that, but for the lawyer's screw up, I would have succeeded with my claim. So a lot of times you'll hear legal malpractice lawyers talk about this as the case within the case. You have to prove two cases.
Yeah.
So every legal malpractice case is not really, it's not one, it's two. So you've got to prove that this person committed legal malpractice, they breached a duty or in whatever way that they did, and you have to prove that the underlying case would have been successful.
Ouch, so, tough. That's a tough standard. Okay, now I can see how that would be a tough hurdle to breach. Okay, so we're talking, you know what? We're getting towards the end of this segment. So before we talk about damages, why don't you give them some contact information for you, Bret? Because I think this is an important area, and they'll at least be able to talk to you, and maybe you'll be able to steer them in the right direction.
Sure. Email is the best for me, really. It's Bret, B-R-E-T, just one T, at BretMooreLaw.com. So BretMoorelaw.com.
Okay, that's great. You're listening to Lewis on the Law, and my name is James Lewis. I'm your host this week and every week. This show actually arose out of a topic from a listener. If you have a topic you'd like to hear discussed on air, go ahead and drop me a line on my webpage. On the very last page, there's a contact page. Go ahead and fill out that sheet. give me a brief description of what your issue is or what you'd like to hear on this show, and I will bring on an attorney who knows about that topic and who's willing to talk about that topic. All my old shows are archived on my website. You can go to jameslewislegal.com and look for all my old shows. If you need an attorney, you can always contact me. If it's a property issue, I can probably help you with it. If it's another issue, a lot of attorneys come through this show. I can always put you in contact with another attorney. You can always give me a call at 404-610-0075, or you can email me at james@jameslewislegal.com. Or you can just go to my website, jameslewislegal.com, and hit my contact page. Lots of ways to get in touch with me. When we get back, we're going to touch on damages and then get into some major considerations. You're listening to Lewis on the Law. You are listening to Lewis on the Law. My name is James Lewis, and I am your host here on Lewis on the Law. I've got a really important topic coming your way, and it's in the spirit of empowering you, the listener, because you, the listener, have to be protected. Your legal rights have to be protected, and there's got to be some way you can do that, especially when it comes to dealing with an attorney. So I have an attorney on, attorney Bret Moore from Bret Moore Law, and we're talking about legal malpractice today. Bret, before we get into it, why don't you tell them a little bit of contact information for you once again?
Again, the best way to get in touch with me is by email. It's Bret, B-R-E-T, at BretMooreLaw.com.
Perfect. So I was thinking, actually, it was my producer who was thinking, because I don't do a lot of thinking, but he was thinking, what if it's a public defender? Are public defenders liable for legal malpractice? Is it easy to sue your public defender after you get tossed up the creek for a life sentence?
Well, there's two questions in there in what you just asked. And is a public defender liable? Absolutely.
Mm-hmm.
Do they have a duty? Absolutely.
Mm-hmm.
However, this kind of gets into the causation defenses area. For actively litigated cases, you as the lawyer have what's called judgmental immunity. You're in court, you're making kind of spur of the moment decisions about how to defend your client, how to represent your client. It doesn't just have to be public defender, but in that context, yes. And so you cannot be held liable for making some kind of a decision on the fly that turned out to be
the wrong decision.
Well, and really, it would probably be pretty impossible to prove that one thing was what made the jury decide to convict you of whatever crime, you know?
Even if it was the evidence, the glove came in when it should have been left out?
Well, you know, those kinds of situations can be grounds for granting new trials.
Okay.
And so then you come into the you have no damages, right?
Mm-hmm.
If this screw up can be fixed,
Mm-hmm.
then there's no damages caused by that lawyer.
Okay.
It's a no harm, no foul situation.
Okay, so let's get into the topic of damages a little bit. What are you talking about when you talk about damages? I mean, is it like they damaged my car afterwards?
In a civil context, damages just means money.
Money. Okay.
You know what?
Very important thing.
Right. So, you know, was your case worth a certain amount of money? You know, did you have an injury case? And whatever the lawyer's screw up has now prevented you from pursuing that claim. For example, very common thing is for a personal injury lawyer to fail to file a case before the statute of limitation has expired. And in
Ouch.
Georgia,
That's a big one.
That's 2 years,
Mm-hmm.
right, from the date of the injury. And so if the lawyer fails to file it, then the client has a claim against the lawyer for the value of that case. What was that case worth? Well, I don't know. It could be anything.
Mm-hmm.
But that would be the damages.
Okay, is there still a causation issue there where they have to prove that they would have won the underlying case had the attorney filed on time?
Absolutely. Yep.
Okay.
And that's the case within the case. You know, every time you've got to show. And so that can be, you know, a lot of times, and we'll talk about this, I'm sure, later on too, but the lawyer, if they have malpractice insurance,
Mm-hmm.
they will have a lawyer.
Good thing to carry.
Yeah, absolutely.
Mm-hmm.
They will have a lawyer, and that lawyer that'll be the first thing that they'll say in the lawyer's defense. They'll say, okay, yeah, we screwed up, but your case wasn't worth anything anyway because you would have lost.
Okay.
And so
Ouch.
that's how they defend. That's probably the first place that they defend these kind of claims.
So, are there other things we have to think about in damages when we're talking about damages here?
You know, really, a lot of people, particularly in personal injury cases and things like that, you know, they talk about pain and suffering. They talk about mental anguish and those kinds of things. If you have, for example, a real estate transaction that went bad, it's very difficult to have pain and suffering added onto
Well,
that.
they usually just pull out. The person still owns their property. The guy still owns his money. It's just gone. It just did not happen.
Right, right. So, you know, people ask that a lot, and you know, the answer is, well, I mean, unless there was some kind of physical impact, you're not going to get pain and suffering in Georgia. So, yeah, I think that pretty much covers damages. It can be very broad, though. I mean, it can be the loss of a business opportunity. It could be, you know, the loss of some
now
contract.
that sounds difficult to prove. Loss of a business opportunity. Is there a high standard for that?
I mean, there's high standards for everything. You've got to. I mean, well, let me walk that back just a second. The standard of burden of proof is a preponderance of the evidence.
Okay.
So, of course, in a civil context, that's what
Yeah,
you've got to show, that it's more likely than not that I would have got this had you not made that mistake.
And that's also the standard on the causation element of the case underlying the case, that you got to show that more likely than not the case would have won. So that's what the standard is.
Correct.
Excellent.
Correct.
Good thing. Glad we brought that out. What other major considerations are we looking at here?
I think that pretty much covers it for the things that you need to have a legal malpractice case. You know, you've got to have that attorney-client relationship. The lawyer did something wrong or should have done something and they didn't do it. And then you have been damaged by that, and it can't be fixed.
Okay. Are there pleading requirements here?
Yes. In Georgia, you have to attach an affidavit of a practicing lawyer who is able to say, I've reviewed the file, I've reviewed the complaint, and what this person is alleged to have done is malpractice based on my experience and all that sort of thing. And again, the standard is what would an ordinary an ordinary lawyer in Georgia do under similar circumstances.
Now, how do you get to that standard? Do you bring in another attorney to say this is what another attorney would have done or your average attorney would have done? Is that what you do?
That's how you have to do it. You have to get another lawyer to sign. It's called a 9.1, Section 9.1. It's a code section, OCGA 911 9.1 affidavit signed by another lawyer. And you have to do this also in the medical malpractice context. You have to get a doctor to sign an affidavit so you can file your case. There's a list in that code section, 911 9.1, of professions where you have to get someone to sign an affidavit before you bring that case.
So you need to have some kind of expert come in here and say this is the standard that this person failed.
That's right. And that's the area where malpractice cases get expensive in the long run pretty fast. You're paying someone whose time is very valuable to review your file and provide opinions about what happened in the case and how it was malpractice.
And it's not, and attorneys who don't come cheap, so you're going to have to pay an attorney on that.
Yeah, it can be very expensive to prosecute. That's why a lot of times if it's a small matter, even if it was malpractice, it can be not economical to pursue it, unfortunately.
Got it. So why doesn't every attorney carry malpractice insurance?
That's a good question. Cost, I think, is probably the major one. Statistics in Georgia, you're not required. We're not required to have malpractice insurance by any law or anything, and that's unfortunately it's one of those things I think some lawyers kind of lobby against. I think we should be required, but statistics show that something like 20% of lawyers don't have malpractice insurance in Georgia. You are, as a client, 100% within your right to ask your lawyer before you sign a contract with them, do you have malpractice insurance? Please show me the deck page. And they should do that. And if they say, no, I don't have it, you're within your rights to go hire somebody else. Everybody's human. Everybody makes a mistake. That's why we have insurance in the first place. So I think it's a good question. It's something that clients should keep in mind.
So is the hiring of an attorney the only thing that drives up litigation expenses during one of these malpractice cases, or are there other things that cause these cases to be a little more expensive?
Yeah, I mean, it could be, again, you go back to that case within the case thing. It could be that if your underlying matter was a medical malpractice matter, now your case is even more expensive than a medical malpractice case was, right? You could have a legal malpractice case on top of a legal malpractice case, which would be 3 cases basically.
Ouch.
Because there would be some case underneath that, right?
Now you're driving up the cost extensively.
Yeah, I mean, experts, in the underlying matter, if you had accident reconstruction people, if you had, if there was just a large volume of documents, if you get into a big corporate litigation dispute, you could have hundreds of thousands of pages of documents, and there are significant costs associated with managing all that discovery. That can be very expensive in a protracted legal malpractice case arising out of that business litigation.
Money. It all comes down to money.
It does.
Yeah. So there's an interesting thing on this outline you gave me, and it's breach of fiduciary duty. I actually have an issue with breach of fiduciary duty, and that is actually happening between a beneficiary of a will and the executor of a will in one of the cases that I'm handling. But you say the lawyer has a fiduciary duty to his client also. Can you expand upon what a fiduciary duty is?
So a fiduciary duty is the duty to act in the best interests of somebody else. And lawyers, we have legal duties that we owe to our clients, but we also have fiduciary duties as well.
You know what? I want to get into that because I think it's an important issue. We're at the end of this segment. Bret, one more time, give them some contact information for you.
It's Bret, B-R-E-T, at BretMooreLaw.com. That's the best way to get in touch with me.
You're listening to Lewis on the Law. You can always contact me at JamesLewisLegal.com. You can email me at james@JamesLewisLegal.com, or you can give me a call at 404-610-0075. If you have a topic you'd like to hear on this show, go ahead and drop me a line on my webpage. And if I don't know enough about the topic, I will bring on an attorney who actually knows something about the topic and is willing to talk about the topic on air. All my old shows are archived on my website. Eventually, every single legal issue you can possibly think of will be archived on my website. It's a good place to go if you need to take that first step in any legal process. You can find out what kind of issues are at stake, what type of attorney you're looking for, what are the relevant facts at hand. When we get back, we're going to get back into fiduciary duties because I think it's a good topic. It's something people need to know about. And we're also going to talk about pursuing claims. You're listening to Lewis on the Law. You are listening to Lewis on the Law. And, I don't want you to take that song. If some of you have guessed what that song is, we're all good here. There is nothing bad going on here because we're empowering you, the listener, with legal information. This show is not designed to take the advice of an attorney. If you have a serious legal issue and you need to contract with an attorney, go back through my website, go back through my podcast. I let all the attorneys give you contact information. So if you think you have a case and you need representation, don't take the advice of this show. Don't take the information you hear on this show because it's all we're giving. We're not giving legal advice. Go ahead and contract with an attorney to handle your legal issue. Once again, you can always contact me at JamesLewisLegal.com. I can direct you to an attorney. You can give me a phone call at 404-610-0075. I know a lot of you have called me already, and I'm always willing to talk to you. That's right. You can just give me a call directly, and I will talk to you, and I'll help point you in the right direction. I have attorney Bret Moore on with me, and we're talking about legal malpractice. Bret, real quickly, some contact information for you.
Email me, Bret, B-R-E-T, at BretMooreLaw.com.
Okay, we were talking about a really, to me, what is an interesting topic, and that's breach of fiduciary duty. And we were getting into lawyer breach of fiduciary duty claims.
Right. I mean, as lawyers, we owe fiduciary duties to our clients to act in their best interest at all times, no matter what.
Okay, so what does that entail?
Well, a lot of times these can come up in legal malpractice situations kind of as a side thing in addition to the legal malpractice. Sometimes they can come up just straight as a claim even if there is no legal malpractice. For example, The rules of professional conduct that all lawyers have to adhere to, these are what we call the ethics rules. They tell us that as lawyers we have to act with diligence and competence, and we have to protect our clients.
Aren't we all competent? I mean, we all took the bar, and the bar is the minimum standard for attorneys, right?
Yes, I mean you're admitted to practice. You should be competent, but there are situations where you may not be. I am not competent as a lawyer to handle a real estate closing transaction.
Oh, and I am not competent to handle legal malpractice claim. That works out well.
But you would be surprised how many lawyers, when something comes in their door and it's a high dollar thing, they'll say, oh, well, I'll take this and kind of figure it out on the fly. And that often doesn't end up well.
If it's a high dollar, and a lot of attorneys I know, because I'm one, are motivated by money. So when someone says, I'm going to give you, throw out a number, $10,000 to handle this case for me, you're hard-pressed not to say, well, of course I can handle that for you, and then try and figure your way out through it.
Right. I mean, as a lawyer, you really need to be able to say, I'm not someone, I can't study to figure this out on this budget or to do justice to this case, so I need to refer this to somebody else who is competent to handle that kind of matter. But the breach of fiduciary duties, that a lot of times comes in if the lawyer has, for example, stolen the client's money.
No, now that's an obvious one, okay? That becomes obvious.
And that's something that's not necessarily legal malpractice, but it is definitely a breach of your duty to your client as their fiduciary, breach of your duty of loyalty to that client.
Okay, so is that all we're looking at here when we're talking about breach of fiduciary duty, just loyalty?
Yeah, there's loyalty, there's candor, and there's diligence. Candor, of course, is truthfulness, honesty. Sometimes a lawyer may make a mistake, or maybe something happens in the case that's just bad, and they just don't tell the client. They kind of do the ostrich in the sand, ostrich head in the sand kind of thing, and that can cause a lot more problems even further down the road. If a lawyer's just, for example, I had a call yesterday where I talked with a woman whose lawyer had filed her personal injury case. He had never gotten good service on the defendant. The insurance company figured out that the case had been filed because he had tried to serve the defendant's father at the defendant's father's address. Mm-hmm. So the insurance company filed what's called a special answer and said, hey, you haven't got good service, and we're answering without, we're appearing specially, answering without admitting service. Mm-hmm. And they also filed a motion to dismiss that case. The lawyer just didn't do anything after that until the case got dismissed with prejudice by the court, which now kills her personal injury claim. She doesn't have a personal injury claim anymore that she can pursue. She's got a legal malpractice claim that she can pursue. But the lawyer could have fixed that. Mm-hmm. I mean, under the law in Georgia, he could have served the guy and then voluntarily dismissed the case, refiled it, reserved it, and cured that problem. But he just didn't do it.
Ouch. Lots of sticky ground there. Let's get back into causation here. How tough is it to get an expert witness in these cases?
It can be very difficult. It depends, particularly if it's a well-known lawyer that a lot of people, know and associate with or like or whatever. That can be difficult to get somebody who's, locally. If you're in a small town, it can be difficult to get someone to go against somebody that everybody knows. There's a lot of lawyers in the Atlanta area, so usually you can find somebody who'd be willing to do it. But not everybody makes a great testifying expert witness either. Mm-hmm. There's certain skill sets for radio.
Yeah.
There's certain skill sets for being in front of the camera. There's certain skill sets for being in court, in trial, connecting with juries, telling stories, all these things. And there's certain skill sets for drafting a contract and closing a deal.
Yeah.
And those lawyers are all very different people. So, you really have to try to find somebody who is going to be good at explaining the problem in a way that a jury can understand easily and connecting with them to support your client's case.
What about let's move on from that and let's get into the economic viability of a claim. How problematic is that?
Yeah, it can be very problematic because of the costs associated with going after a lawyer. I get these calls all the time. I've got a malpractice case against my lawyer. He messed some stuff up, and I know he's got insurance, and I know that they're going to settle this case, and so they're just going to roll over quickly. That almost never happens.
Yeah, attorneys tend not to roll over.
No.
Unless they're handling someone else's money, and then they're like, "Why did we settle?"
Yeah, well, I mean, typically if they've done something like that, they've got a lot worse problems. The issue is, lawyers, we are trained in fighting for our clients. And if someone comes at us and says, you've done something wrong, our first instinct is, well, wait a minute, and I'm going to fight. And that's what they do. They almost to a man and a woman, they almost always want to fight for, at least some length of time. I would say the average legal malpractice case probably lasts about 3 years.
It lasts 3 years, so it takes a long time to collect on something like that.
It can. Now, I've had some that resolve very quickly. I've had some that resolved in a couple of months. If it goes to litigation, and they usually do go to litigation, then 2 to 3 years.
Now, is that true? Legal malpractice claims almost always go through, or usually go to litigation?
Yes.
Because I know a lot of property litigation disputes, they start out and they seem like they're going to go towards litigation, but somewhere just before it actually happens, there's a settlement that occurs.
Yeah, no, I mean, the same is true for all civil cases, that they almost never go to trial. Mm-hmm. And legal malpractice cases, I think, are even more rare than regular cases to go to trial, because the lawyer really understands there's a huge risk.
Yeah.
The jury sees a lawyer as a defendant, and they hear about all this conduct. They're gonna just hammer him.
Yeah.
Which I think that's a motivating factor for the lawyer to settle the case. So they don't usually go to trial, but they almost always get litigated for a long period of time.
That is rough. Long periods of time with litigation. That sounds really rough.
It's a tough business, but I love it.
You're a better man than me, because I like my money to come in a little bit easier than that.
I like a challenge.
That does sound like a challenge, because I can imagine that if I got sued for that, I'm immediately putting up a lot of defense. I carry malpractice insurance, so I'm like, yeah, this isn't going to happen. Are there other risks for an attorney who loses a malpractice case? Are there bar implications? Yeah,
the bar stuff is totally separate from malpractice, although they kind of overlap a little bit. A bar grievance is something that the client would complain to the bar about the lawyer's conduct. The bar would then send a letter to the lawyer and say, okay, we think you violated rules, and then list out all the rules. Please respond. Here's an important thing for all the lawyers listening. Check your malpractice insurance coverage, because you almost assuredly have disciplinary defense coverage that will pay for you to have a lawyer to respond to the bar, so that somebody else is dealing with this for you, and you don't have to pay a deductible.
Yeah, you don't want to have to deal with the bar. We are at the end of this segment. When we get back, I want to talk more about some damages, and I want to get into some specific cases here that you've gone through, and maybe even the questioner from our listener. George, this goes out to you, because I know you listen to this show every single week. Bret, one more time, give them some contact information for you.
Email me. It's Bret, B-R-E-T, at BretMooreLaw.com.
You're listening to Lewis on the Law. My name is James Lewis, and all my shows are archived on my website. You can go back through it and take a listen to any legal issue that you have and kind of get pointed in the right direction. Once again, this show is not meant to replace the advice of an attorney. If you have a serious legal issue, go ahead and contract out with an attorney. This show is only designed to give you information. It's designed to be your first step in any legal process. It'll give you an idea of what type of issues are at hand, what type of attorney you're looking for, what you're not looking for in an attorney, which is kind of what this show will kind of touch around, that we're not telling you what not to look for. We're kind of pointing you into where some problems might arise if your case is actively ongoing. When we get back, we're going to talk more about some damages, malpractice policies, and we're going to get into some actual case studies. You are listening to Lewis on the Law. My name is James Lewis, and I am your host this week and every week. And the goal of my show is to empower you, the listener, with legal information, because I know deeply that even if you are ignorant of the law, you can be very deeply affected by the law. So, in that spirit, this show is extremely important. We're talking about legal malpractice, and I am here on air with attorney Bret Moore from Bret Moore Law.
That's right.
Bret, will you give them some contact information for you?
Yeah, the best way to get in touch with me is to email me, and it's Bret, B-R-E-T, at BretMooreLaw.com.
Excellent. So I would like to wrap up kind of where we are, because we threw a lot of information out there. And so this segment of the show, I like to kind of go back to where we've been. So what are the threshold requirements for pursuing a legal malpractice claim?
Have to have an attorney-client relationship with the lawyer. That lawyer has to have done something wrong or failed to do something that they should have done, and that has to have caused you some damage to where, the loss of the claim, some other economic injury of some kind. Those are, and then you have to have a lawyer who will sign an affidavit saying that what that person did was malpractice. It was below the standard of care of ordinary lawyers in Georgia. And that's a pretty low bar, isn't it? Yeah, I mean, it's not a low bar because we had to pass the bar exam, which is not an easy thing to do.
And the worst thing about the bar exam is, on I don't know if you did Kaplan or Barbary, but on those preparation courses, they're like, these are the minimum competencies for a lawyer. And then you get in there and, it's really difficult. Luckily, I passed on my first time. But, I think that standard is actually a pretty good standard.
Yeah, it's tough. I mean, the exam itself, there's so many things, and then when you get into practice, I'm telling you should not do this, right? You shouldn't try to be everything to everyone, because
that's a bad road.
It's a recipe for disaster.
It is.
You cannot possibly be competent in all fields of the law.
That's true. Now, are all types of damages covered by malpractice? I mean, we've talked about malpractice insurance, and it's basically a good thing to have. Are all types of damages covered by malpractice insurance?
Yeah, they may not be. For example, intentional acts are often not covered by insurance. The lawyer steals your money, that may not be covered by the insurance.
Wait a minute, the lawyer steals your money and that's not covered?
Yeah, potentially not. Any kind of intentional act, for example, if you auto insurance, if you crash your car negligently, that's covered. If you purposefully drive your car into someone else because you're mad at them, that's an intentional act. That's often not going to be covered by the policy. The attorney's fees may also be excluded from the malpractice policy. So if you have for example, in a family law context, a divorce lawyer has just, that's been very protracted litigation, and they've just run up a huge bill. I've gotten those calls before. My lawyer billed me way too much money. What's going on here? I want to sue them. Well, you may have a claim. They may have committed malpractice in doing a bunch of work that was not necessary, or, doing things that had no effect. Or they may have breached their fiduciary duty in overbilling their client. But the policy itself may say, we won't cover any damages that are characterized as attorney's fees. So that can be another thing where, you may have a successful claim. You could win and have a judgment from a jury, but the policy won't pay it. You're going to have to go and then collect it from the individual, from the lawyer or the law firm. As we know, you go into court. Well, you may not know, you're not a litigator.
I've done some, but,
right,
but it's not my primary area.
Right. I mean, you can go and get a judgment. That's the first step.
Mm-hmm.
Collecting on that judgment is step number 2, and it's a totally different experience.
Liens and more.
Right. Yeah.
So you touched on breach of fiduciary duty. That is actually something else I want to cover in the wrap up. Briefly, what is a lawyer's breach of fiduciary duty to his client?
Okay, so lawyers owe duties to their clients, fiduciary duties to their clients. Candor is one of them, truthfulness, honesty, loyalty, to act in their best interest at all times, and diligence. You can't just sit on your client's case.
You can't?
No.
Can you prioritize?
Yes, you can do that. One of the things, too, that you can't do is you can't abuse your position.
What I can't say, I am the all and great and mighty attorney, and you must listen to me.
Yeah, no, there's
You're like, yeah, no.
Well, that's actually a serious issue, particularly in PI cases, personal injury cases. It's the client's case. So, and these are in the ethics rules. The client has the authority to settle the case or not, and the lawyer must abide by that decision. A lot of times, clients will call me and they'll say, "Hey, well, my lawyer settled my case and never talked to me."
I've heard that, and I've heard that one myself.
Yeah, and that's a very serious problem because sometimes the lawyer has, for example, they may have gotten all the money that they thought about on one particular policy, but they didn't think about some other policies that they could have gotten, and they've now settled this claim and foreclosed that opportunity.
Another thing that I've heard often is the insurance company gave me a settlement and my lawyer turned it down without consulting me.
That's right. You have to present that offer to the client so that they can make that decision. It's their decision. And the client really has the opportunity to talk to another lawyer if they want. And sometimes I've told my clients that too, if it's a personal injury case that I'm handling. Hey, look, this is what I think about this, and if you disagree with that, go talk to another lawyer and get get a second opinion, just like with doctors about surgery or anything like that.
Where does the statute of limitations fit into all this?
That's a very important thing to keep in mind. The statute of limitation for legal malpractice in Georgia is traditionally, it's been held to be 4 years, and that's based on a oral contract. If you have a written contract with your lawyer, it might be subject to a 6-year statute of limitation. That has never been tested in the courts yet. With respect to lawyer contracts, it has to be what's called, quote, sufficiently written, sufficiently definite for that 6-year statute of limitation to apply. So it could be 6 years. It's probably 4 years. You should file your case before the 4 years expires.
Wait a minute. It could be 6 years, but it's probably 4 years?
Yeah, I would not try to be the first case to test that.
Got it.
You don't want to be first on that because you might lose. So, and then the statute of limitation on breach of fiduciary duty is probably 2 years because that's kind of a tort-like claim. So,
okay, what types of things, since we're empowering the listener, what types of things do we want people to look out for when an attorney is handling their case?
Important things as the client. If they're not answering your questions timely, that's a red flag. If they keep putting you off on a paralegal, you can't ever get in touch with the lawyer at the office, that's a red flag. If you can't find out what's going on in your case, and nowadays you can see online, you can go and search because we've got mandatory e-filing in Georgia now. A lot of that case information is available online. Go and check and look. You can see what's going on in your case, and if there's something that's happened in your case that your lawyer hadn't talked about with you, that could be a problem as well.
Got it. So before we close out, I want to touch on a question on this area by one of our listeners. George, this one goes out to you. So the attorney has filed the wrong complaint in a cremation action, and I know you don't handle that type of law,
right?
But is there a malpractice issue here?
There may be, and the answer is, I don't know. And if he had come to me with this potential case, on the front end, I would have said, hey, look, I don't know what the law is on Georgia about dealing with bodies and disposal bodies and who's got authority to do what. I would send him to someone else to talk to first. If he's talked to somebody else and they have said, oh, what this person did is malpractice and it cannot now be fixed, then there could be a malpractice claim there. What the damages would be very difficult to determine,
And then that is going to be a deterrent to most attorneys from handling that type of case.
I would tell him, look, do you want to spend thousands of dollars on an expert and go and litigate this case to try to recover something from these lawyers who are going to fight, as we discussed?
Of course,
right?
they're going to battle for their lives.
They're not going to just roll over. So, it's one of those things where I think that case probably does not make sense to go and litigate.
Thanks a lot, Bret. You have been a great guest. Go ahead and give them some contact information for you real quickly again.
Again, best way to get in touch with me is email. It's Bret, B-R-E-T, @BretMooreLaw.com.
awesome show. We are at the end here. My name is James Lewis. Of course, this show will be on next week, and every single week I will be your host. Before we leave, I would like to thank the magician of music over there, our producer, Sam Davis, the vixen of video, the magician of multimedia. Why the vixen of video? Don't ask me. Anthony Cook. Thanks a lot, guys. We had a great show. I will see you guys next week.